Hello, there have been some updates to the Star Citizen vs Crytek case. Please check out my original overview video on that case if you don't know anything about it, as this is an overview of the updated information. Everything that is stated here is my opinion, or based on information as I understand it. I am certainly no expert on contract and IP law. Back in December, it did sound like Crytek might have had some form of locked-in exclusivity agreement for Star Citizen, and may possibly have had at least some recourse to damages. However, we now have the game license agreement, which CIG have provided, and a lot more information about the case, amendments, and a move for dismissal from CIG. So CIG's preliminary statement, their response to Crytek is, this action should have never have been filed. The first amended complaint, the FAC, like the initial complaint filed before it, sacrifices legal sufficiency for loud publicity. Though Crytek twice now conceals the actual game license agreement from the court and the press, the court possesses the power to examine the incorporated GLA on this motion. The GLA eliminates virtually every claim and remedy Crytek seeks. Crytek's admission that the defendants are not even using Crytek software gets rid of the rest. The allegations regarding the defendants' co-founder, Ortwin Furamuth, and other employee Carl Jones, the offending allegations, though modified in retreat by Crytek's counsel after being confronted with a Rule 11 motion based on a false allegation contained in the initial complaint, still bear absolutely no material relation to any claim or named party, and have everything to do with generating misleading, scandalous press. Neither of Crytek's two contrived claims can survive the contract, and its remedies are contractually barred, justifying dismissal as a matter of law. The court should also send a message to Crytek by striking the immaterial, impertinent, and scandalous offending allegations in paragraph 15 of the FAC. So, there is a huge part of Crytek's claim which centres around the use of the word exclusive and exclusivity, where Crytek say that Star Citizen is obligated to use their engine, but the GLA appears to suggest that this refers to Crytek and Star Citizen being able to continue to develop their own engines and games without having to worry about each other, rather than any obligation for either party to use it, which would be a pretty standard agreement. Leonard French referred to this as a knockout punch to Crytek, and Leonard French is a copyright lawyer and has done a big video about this subject, which I will link in the description below. There is nothing mentioned in the restrictions section of the GLA which would prevent CIG moving engine or stopping them use CryEngine. Another part of the case was that Squadron 42 wasn't part of the agreement, but it also appears that the GLA recognises Star Citizen and Squadron 42 as different games, and CIG were able to develop for both of them. Though as Star Citizen and Squadron 42 are no longer using the CryEngine at all anyway, it might be entirely irrelevant. CIG go on to say that Crytek has attempted to contort the term exclusive to mean that CIG had to use their engine forever, but they state that the term exclusive refers to the ability for CIG to use their engine for the game and not give those particular rights to anyone else. Basically, the term exclusive is used to protect CIG's license, not restrict it. There was some other interesting information here too. The claim was directed at both CIG and RSI, though RSI don't seem to be any party of the GLA or contracts with Crytek at all, so they shouldn't have been part of any case at all, it appears. Star Citizen paid 1.85 million euros for a buyout license agreement from Crytek for their license, so if you wanted to know how much their license was, there is a provision in the GLA that precludes either party from being liable for any damages, which is very odd. It implies that potentially either party could end the contract at any point with no repercussions. But it looks like, for what most of Crytek was saying, there are provisions in the GLA which kind of dismiss it effectively, which make it irrelevant, or say CIG were well within their rights to do things. With that in mind, CIG have moved to have Crytek's case dismissed in its entirety. Interestingly though, they asked the court to also strike the scandalous and false allegations regarding Furameyer and Carl Jones, referring to Crytek attempting to hand-fistedly smear Ortwin and Carl Jones's reputations. In respect to any other conflict of interest as well with Ortwin, it may appear that there was a signed conflict waiver, so it was an odd complaint to make in the first place from Crytek, as they would have known that he had that waiver, he had that already resolved. There is still the potential that something else might come to light, or there is something incorrect in the documents, or CIG have not filed something properly, but it looks to me that CIG and RSI have acted reasonably and well within their rights, according to that data that I can see there, to be able to change their engine and to no longer use the CryEngine if they don't want to, whatever. It's possible that we may see more on this at a later date, or it might get entirely dropped now. We'll have to wait and see though, as there might be underlying details we're unaware of, but Leonard French said that he'd also bet on a judge agreeing with a motion to dismiss. My sources for that overview were Leonard French, a copyright attorney and YouTuber who has done a massive live stream dissecting all that information. He does a great job. I will put links down below. And the updated documents themselves, CIG's responses, the FAC, the first amended complaint, and the GLA, the Game License Agreement, which I will put to links of everything down below so you can peruse at your pleasure or displeasure or whatever. If you like reading that sort of stuff, if you want that stuff to hand, then it is now there. Every month we have a giveaway for a ship. For January, it's for a Hammerhead gunboat donated by our featured org, IDF, the Intergalactic Defence Force. They're a lawful org that focus on trade, security, escorting and teamwork, as well as dabbling in other areas of the game. Links below if you're interested in checking them out. They are active now in Star Citizen Alpha 3.0. All you need to do to be in for a chance of winning that Hammerhead, though, is be subscribed to my YouTube channel and then comment on any of my Star Citizen content during this month. Do you have any questions about Star Citizen or Squadron 42's development, gameplay mechanics, about this case, about anything the original case documents had, or the new updated ones, or whatever? You can chuck them in the comments below. A special thank you to my Patreons, who allow me to create the amount of content I do, and if you're interested in becoming one of them, you can find the links to Patreon, as well as everything else we've discussed down below too. Please don't forget to like and subscribe, as it really does help me, and I'll see you in the verse.